Join former FBI senior forensic examiners Becky Passmore and Stacey Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths. These badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacey's obsession. This podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Parsing the Truth one bite at a time is proud to welcome our first sponsor, Ace Forensics. They are based near Chicago and they've been building systems since 1983. Ace Forensics delivers high-performance digital forensics workstations, laptops, and servers to justice agencies across the United States and around the world. They offer unmatched value and the industry's only 5-year digital forensics warranty. Ace Forensics build the systems your digital forensics software deserves. If you're procuring digital forensics equipment, reach out to them for a competitive quote. Now, on to our episode. Welcome back to Parsing the Truth, one bite at a time. I'm Stacey Eldridge, and with me, as always, is my co-host, Becky Passmore. And we are the true crime podcast that focuses on digital forensics and the facts and the artifacts of the case. We talk court cases, our own cases, and we also bring other digital forensic examiners on to share what they've learned from their work. Tonight, we continue our focus on court cases. Becky, what are we digging into today?
So we're still in the Karen Reed trial. And so Today we are diving into the second half of Richard Green's testimony. So if you recall last week, he is the digital forensic expert called by the defense to testify in the first Karen Reed trial. If you haven't listened to last week's episode, you'll want to go back and listen to part 1 of Green's testimony. Here's a quick refresher regarding the first half of his testimony. The big takeaways from the testimony included his finding that O'Keefe arrived at 34 Fairview Road at 12:24:28 a.m. That is supported by location, cache data, and Apple Health records showing steps, distance, and floors climbed in that same window. He also raised questions about timestamp reliability by pointing to Waze using a monotonic clock that ran about 3 minutes faster than the standard wall clock time.
The most consequential part of his testimony centers on Jennifer McCabe's phone, where Green says he found a deleted Google search for "house long to die in cold," time-stamped at or before 2:27:40 a.m. on January 29th. And it's consequential for 2 reasons. First, it directly conflicts with both the conclusions of Jessica Hyde and Ian Whiffen, who testified for the Commonwealth. And secondly, this search implicates someone else in the death of Mr. O'Keefe.
Yeah. So let's pick back up with Green's testimony. Remember that this is his direct testimony, and the defense counsel is asking the questions. At this point, the testimony turns to exhibits regarding data and exhibits from McCabe's phone. Green is shown exhibit MMM.
Contacts Uncle Brian A.
A Celebrite report that lists out a deleted call record from McCabe's phone to Uncle Brian A. There's an objection and a sidebar. It looks like it's entered as Exhibit 655. Remember, we'll link the exhibits to our show notes.
And now there's another exhibit shown in the court. And this one is a report from Celebrite from McCabe's phone that lists the call log with a number of deleted and live items. It's entered into court as Exhibit 656. Now, when he's asked what he found of note, he said it was the timing of the records, that the deleted call records start at 5:33 a.m. on January 29th and then end at 8:50 a.m. that same morning. And the call logs that are still active, meaning still live,
don't begin until 8:59 a.m. and then they continue on throughout the day with no more deletions.
Okay. So when asked what the difference was between the calls at or after 8:59 a.m. versus the calls at or before 8:50 a.m., he answered that it was the state of the record. Deleted versus live data and deleted data in the earlier time. There's another question asked and the judge calls the counsel up.
When counsel returns, Green is asked what percentage of the calls between a.m. and 8:50 a.m. were deleted, and his answer was 100%. Then he asked if he was aware of the term spontaneous deletion, and he said no. He knows what the individual words mean, though.
When asked if he had an opinion as to how those records would have been deleted from the phone, he answered that they would have been user deleted, and that ends the direct examination.
So now we're going to be moving on to the cross-examination. So this is the Commonwealth. The prosecutor now has his chance to ask Mr. Green the questions he would like answers to. First up, he asks Mr. Green if he knew who Jessica Hyde is and that she wrote a report, and asked if he had a chance to read it. And he answered yes. And then he asked Mr. Green the same questions about Ian Whiffen, and Green also answered yes.
And when he asked if he understands that they both disagree with his findings, he said yes. Then they got into his certifications. What certifications does he have with Celebrite? He states he has much broader certifications. He doesn't have any Celebrite certifications specifically, but he's attended Celebrite and Belkasoft training classes, hundreds of them.
When asked directly, you have no certification in terms of Celebrite and how to use it, he answered no. And this is a common tactic from either side. They're always going to ask you about certifications, degrees, and whatever, and pick on whatever they can, whenever they can. And it's happened to me. It's just tactic 101, right? Now they're moving back into the case. He was asked who he spoke with at Celebrite regarding the issue of the house long to die in cold search. And he names two individuals in technical support who indicated that they escalated the issue.
He was asked if he was told it was being escalated to Mr. Whiffen's team. He wasn't aware of that, and no one reached out as far as he knew. He agreed that the defense asked him to look at O'Keefe's, McCabe's, and Reed's phones, and he was never asked to look at Robertson's phone.
They moved on to Reed's phone and whether it had any location data. He said he found map tiles, and he said for those to be present, he said location services had to be enabled. As far as I can tell with that statement, Green is referring to the Apple map tiles that make up the images that you see when you are in the app Apple Maps. And these map tiles are going to be generated even when you're simply looking at stuff in Apple Maps, as far as I know. And as far as I know, you don't have to be driving or navigating somewhere with like turn-by-turn directions to have Apple map tiles generated. He didn't mention if he could figure out if any of those locations or places identified in the Apple map tiles, what they were, where they were, nor did he share any dates or times associated with these Apple map tiles. So I just don't know that location services has to be enabled to use Apple Maps. Now, Becky, my iPhone friend, do you ever use Apple Maps? Does it force you to enable GPS even though you just like say want to look something up or just type in the address first? How does it work for you as the user?
So you can use Apple Maps. I can choose Apple Maps or I can choose Google Maps. I prefer Google Maps over Apple Maps just because I like the navigation process. They're both on by default, so you have to disable them. And then you are not forbidden from using, go ahead.
I was going to say, you mean that that your GPS, your location data is on by default on your iPhone.
Correct.
And you'd have to take extra steps to shut it off or
Your
disable it.
Disable your map services.
Well, yeah, but I'm just talking about like location data. You can have it on or off.
Absolutely. Yeah, for sure.
Yeah. Same thing on the Android. You can shut it on or off.
So yeah, you're not forbidden from using Apple Maps if GPS location services is disabled, but its functionality will be severely limited. You can still open the app look at maps and search for locations, but you'll not have a blue dot showing your current location, and turn-by-turn navigation will not work. So they're not having it enabled. There's restrictions versus having it enabled and functioning like a map tool.
Right. But so the mere presence of a map tile, an Apple map tile, does not indicate that location services is on or off. It doesn't do it either way.
That it was being used.
Interesting.
Continuing with the testimony, Green states he doesn't know how the phone was preserved. He doesn't know if they had done things like airplane mode and Faraday bags, and whether that would have affected whether the location data remained. But when he got the extraction, there was no location data present. When asked directly, so there was no GPS location data present from what you observed, he said he found deleted location data from April 2022.
Next, he was asked if he found deleted web data from Reed's phone, and he answered, no, I didn't observe it. Then when pushed, he was asked, did you not, or I guess the prosecution was stating, did you not observe it or did you not look for it? He ultimately answers he can't recall and he doesn't believe he had reason to. Now, there is a protocol for if you can't remember stuff. Some courts are more strict than others about like the protocol that you have to follow in order to be able to like look at your notes and reports. But this one seems to be pretty easy. You can just say, may I look at my notes? May I look at my reports? You can even say, may I refresh my memory? And generally the judge will say, yes, you can do that. So don't think as an examiner that you have to memorize all of this stuff and your memory is all that you have to go on in the courtroom. Bring your notes. I even ask if I can just bring in my tablet. And every time I've asked in the last couple of years, they said yes. So I didn't even have to print everything out. So it just depends how you like to work. Do you like a big stack of paper binders with lots of tabs and things, or do you want to use your tablet? But so bring that in. And I do not recall watching Green walk to the stand if he brought anything up with him or not. But do all that pre-work to make sure you can bring stuff up with you, find out what the rules are, ask your attorney that so you can come prepared. So when they ask you a question, or like every one of us who's been on the stand, you have that momentary what, and you can't remember something, look at your notes.
That's right.
Okay, so moving on. Next, there is a question about location accuracy and it being within 3 feet and the exhibit that was created after Guarino testified and why it was created. Now, remember, this exhibit was basically the first thing he talked about when he got on the stand after they did all the introductory stuff about who he was in his company. So he goes on to answer the question. There's some rambling about it. And ultimately he kind of, says he'd have to ask the lawyer.
He was then asked if he knew that the 3 feet accuracy that was testifying about had nothing to do with cell phone data. And he said he didn't know. He wasn't aware it was related to the cruiser cam video that Guarino was testifying about earlier. He just didn't know.
And that makes total sense. I'm most certainly sure in this case, the rule was invoked. So it's not like he could be sitting in the courtroom watching testimony and nobody can be telling him exactly what was said. Nobody else that was testifying could tell him what was said either. So that makes sense that he doesn't know exactly what was going on with that. Next, he was asked if he was aware of what Guarino testified about yesterday. He begins rambling again. Some of the things I pulled out of that was he said it was vaguely familiar. He said he was not trying to not answer. Then he continues to discuss the question that was specifically raised by his lawyer regarding whether GPS could be so accurate within 3 feet. He answered that it's not known to be, especially within Apple services. And then he said he's happy to opine on location data, and the prosecutor said that was not the question.
Then he was asked, isn't it true there's no way for a user to delete a tab, but only to close it? Wouldn't you agree with that? And he answered, yeah, well, when you close a tab, you're taking it out of the active state and it's going to an inactive state that some people could call deleted. Stacy, you and I have talked about this before. We know people in general are talking about interacting with the phones and internet browsers. And we've never known anyone to close deleted their tabs or closed them. Like, that doesn't make sense.
Yeah, they don't say deleted.
No, they don't
They say
call closing their tabs deleted tabs.
Yep. Yep. Now he continues. He states that the Safari history will allow you to go in and delete history by certain date ranges. You can go into specific websites that you've visited and delete those as well. Regarding the WAL file itself, a user can't open it up and say, I want to delete this record. But the phone, through different user interfaces, will have an effect of deleting data within that WAL file. So as digital forensic examiners, we're often examining records that have been deleted. Sometimes the user took the action that resulted into that record being deleted. Other times it's the system operation that resulted in that record being deleted. And those last couple sentences, so as digital forensic examiners, that's our commentary on that. Just to be clear, that was not what he said on the stand.
Yeah. Then he was asked, isn't it also true that Celebrite uses that red X to annotate that the record is no longer active and has been recovered, and then makes it incumbent upon the examiner, being him in this instance, to determine if it was actually deleted? He answered yes, and then the prosecutor cut him off. He goes on to confirm he also used the Sanderson's forensic SQLite tool, and that he observed the house long to die in cold search in it.
I've been very impressed in this trial with the digital forensic examiner testimony. There's not been a lot of cutting them off. They've been allowed to talk, even on the cross. So that was a rare one for him to be cut off. But anyways, next he's asked if he independently verified the cause of that timestamp that he observed, and he said yes. When asked if it was his interpretation of that timestamp, that means the search appeared at the time that he's stating, and it was solely based on the naming of the field in the database, he said no.
Then he asked, can a WAL file contain items that are so new that they are not yet committed to the database? He said yes, that's the purpose of it. And the WAL file holds the newest information until it's merged into the database, including additions, deletions, changes, all of those items, correct? And he stated that is correct.
Next, he's asked if in his affidavit he stated that McCabe's phone was in active use between 2:23 a.m. and 2:31 a.m. And he was asked what other searches he saw in that time frame and where they were performed. He answered that there were a number of websites, including the Raining Men, which was in an exhibit earlier, the Ozone Basketball, the Hockomock Sports. And he said similarly, the last entry is the browser state DB entry. He says he has a couple of thoughts on why that may be regarding Ms. Hyde's and Mr. Whippen's testimony, and he's happy to share that.
The attorney replies, I'm not asking you anything about that. What I'm asking is it possible for a change request in the WAL file in the SQLite database pertaining to one particular field, leaving the other fields as they were previously?
Green asks him to repeat. The lawyer repeats the question. Green states he's having trouble answering this. Green responds, Green responds, if I'm understanding correctly, when the WAL file gets written to the database, it could have made the change ending with this deleted record. Is that the question? He continues, I'm sorry, I want to answer you. I'm just a little lost on how you're asking it. The lawyer asks, do you not understand the question? The judge directs the counsel to move on.
So then he's asked, is it possible that the URL field, which has the website name, was updated to the newest search while the timestamp retained the original search? Is that possible? He answered no, not that way on this particular phone and this particular iOS. And also with the user interaction with it, that would have been at 2:27 a.m. or before. The way this very specific iOS was working is consistent with all the other ones that he observed out there on the phone related to specific web searches and activity.
Then he was asked if it was possible that the search for How Long to Die in the Cold at 6:24 a.m. was the most recent search completed in the tab. He answered, well, not in that tab, but I certainly agree with you that there was a second search done around that time.
Then it was asked, is it also possible that the search that you assert took place at 2:27 and 40 seconds in the morning is the same as the search that took place at 6:24 and 51 seconds a.m. for that same search? He answered, that's inconsistent with the actual data that I'm seeing on this actual phone with this precise iOS version.
Then he was asked, as far as the search in Safari with the search string that included smoot.apple.com, do you recall that search being a suggestion from Apple from the iOS as far as the search with how long to digest food? Now, our commentary, if you guys recall, Jessica Hyde gave testimony on that previously, and she discussed that smoot.apple.com being an Apple suggestion. So you can always go back to her testimony and check that out again. Now, Green answers that he didn't hear the whole question, but he heard the last part about how long to digest food. His feeling on that is when the how long to die in cold was put in, that was because it was most likely an Apple suggestion.
He states he's done some testing, but his testing is after the time period. When he tested, he could see that how long to digest food would come up. He also noticed that specific phrase, how long does it take to die from hypothermia? So when trying to repeat this, those are the two suggestions that came up. We have to pause here and make a note that what you may see as a user and what may be logged can be two totally different things. It's unclear from Green's testimony what exactly he was looking at for the results of his testing. Was he simply looking at browser and seeing what was appearing in the browser as he typed?
That's a great point, Becky. Was he trying different combinations of typing out the words for how long to, and then seeing what actually got logged by that very specific iPhone running that very specific iOS? It's unclear what he was looking at. Let's go back to his testimony. The prosecutors asked, was it something that was a suggestion and not something that was actually searched? He acknowledges that this is different from his affidavit. He says, in fairness, he wants to give his best knowledge as he understands it, sitting here today, including that this is after his review of Mr. Whiffen and Ms. Hyde's reports. And so since that time and doing searching, he would notice that one of those things would come up, or one of these things would come up, and that was a little picture of a dinner plate or something like that. And it was actually very similar to, if not the same picture he found in the artifacts of that iPhone.
The prosecutor says, just to conclude, that's not what you said in your affidavit. That was actually filed under pains and penalties of perjury with this court. He answered, correct. Yes. And on that day, that is what my true belief was. Since further testing, he now believes that what was probably an automatic, it was probably somewhat automatic. And if he's caused any distress, he apologizes.
The prosecutor responds, you haven't caused me any distress. That's what you filed because that's what you thought at the time, correct? Green says, correct. Then the prosecutor continues, subsequently, you've done further testing and that's shown you were wrong. And Green answers, correct.
So the prosecutor asks, according to your affidavit, there was a search for how long to digest food at 6:23 and 49 seconds in the AM that precedes the search for how long to die in cikd at 6:23:51 a.m. Is that correct? And he answered yes.
Next, he's asked, is it possible that the how long to digest food was a predictive suggestion from Apple rather than a search entered by the user? Is that also correct? He answered, I don't know the answer to that. He continues, he believes that it had picked up on an earlier search from 2:27 a.m. of how long to die in cold. And then the user went in to retype it, and the phone may have tried to give something similar. during that 6:23 and 6:24 a.m. Now, to be fair, there's probably a line somewhere in there, and this is me talking, about what's predictive and what's a suggestion. But if we just focus solely on that URL, the one that contains the smoot in there with the how long to digest food, the key takeaway needs to be that the user never typed in how long to digest food. This was a suggestion that came up. Now, what drove that suggestion? That kind of comes in from the predictive stuff, and that's the line. But I think, like, if this was your testimony, you'd want to make it clear that someone did not type that in. That's the key takeaway here, in my opinion.
Yeah, and here's an interesting note. He just got done testifying several questions ago that he believed the how long to digest food was a suggestion. So it's unclear if he's not tracking the smoot.apple key to identify the fact that the how long to digest food was a suggestion from Apple, or if he's trying to go deep into the weeds and figure out what words the iPhone was predicting the user would type. But if you're unclear on what the question is, you can always try to rephrase to make sure everyone is on the same page. Now we're going to move on because the prosecution isn't going to ask any more questions about that, as they are now moving into the Apple Health data.
Green is asked, regarding Mr. O'Keefe's health data, steps don't necessarily mean that someone is physically taking steps. He answered, based on his research, steps tend to be a very accurate artifact. Then asked, so steps cannot also coincide with movement in a car or any other sort of movement on the phone as far as health data is concerned?
He answered that he did do some testing with an actual iPhone 11, the same make and model, and took a drive and tried to see if it would register steps. It did not. He sat in a chair and tried to duplicate how he thought he would walk to see if it recorded steps. It did not. He took the phone from the floor to the ceiling to see if it would record a flight of stairs, and it did not.
Girl, we have all been there with this sort of testing.
Yeah.
You know, can we drive with the phone? What happens? Can we toss the phone around and see what happens? My answer tends to be, it might log it, it might not. And the problem is because Apple doesn't tell us how any of this stuff works. All of these answers and conclusions we have drawn is from our own testing and validating, other examiners testing and validating. And there are some really good papers out there that have been published that have been peer reviewed. So if you have to testify about this sort of thing, go and look for those peer reviewed papers and see what they say. Add that to your research, add that to your toolbox. Now, who knows? We might just end up talking about this sort of thing again regarding testing a phone by tossing it around in a future episode about some stuff that's going to be coming up pretty soon. But back to his testimony, Green says that with that iPhone 11, same make and model, it was very consistent with him actually doing walking steps, and that whether it was held by his hand or his shirt pocket, pants pocket, clipped onto his belt. Then when asked if that was his testimony, he said yes.
He was asked, are you familiar with GPS native locations? He said yes, and continues that GPS native locations takes data from a number of different sources. True GPS takes it from the GPS network. He says, what you may be thinking of is assisted GPS, which the iPhone uses, and that assisted GPS will try to source. It will look at cell towers, Wi-Fi, and a number of other devices to try to get you enhanced GPS location and give you the best data possible.
He's then asked, so it takes GPS native locations within an Apple iOS device from 4 different sources. Isn't that correct? He answered, it tries to get it from a variety of sources, like he just mentioned, not all of which would be available. Green also confirmed that he looked at the GPS native location data on Mr. O'Keefe's phone. Then when he was asked if he would agree that the GPS native locations didn't record any movement of that phone after 12:25 a.m., he answered that he would have to look at the exhibit to see what the time of that last entry was. He doesn't want to misstate something.
So when asked, you were asked about the elevation change in 3 floors, ascending and descending, and you said you couldn't pinpoint a time within that 1221 to 1224 time period from the health data. Is that correct? He answered correct. It happened somewhere within that time. Asked, could you pinpoint more specifically if you looked at the GPS native location data? He answered, no, we are talking Apple Health and GPS location. I think what the prosecutor is trying to get to here is that he's wondering if Green made any correlation between these two different artifacts. He's wondering what is happening simultaneously and what that means.
The prosecutor states, you said you couldn't pinpoint it. Then Green replies, I'm sorry, which one are you asking about? The attorney replies, what I'm asking is, you said you couldn't pinpoint it within the GPS or health data if you had looked at the GPS native location data. Could you give a more specific pinpoint as to where Mr. O'Keefe's phone was?
There was an objection, and the judge allowed the question in. The prosecutor restates the question. There is another objection and then a sidebar. Upon return, the prosecutor asks, earlier in your testimony, the elevation change from 1221 to 1224 could not pinpoint specifically where in that time period the elevation change occurred. He answered, that's correct.
The prosecutor continues, so what I'm asking is, had you looked at the GPS native location data, would you have been able to more accurately or specifically pinpoint when that occurred? He answered, yes. There was location data within that time period.
So ask, are you aware that Mr. O'Keefe's phone from the GPS native location data was actually a half-mile away from 34 Fairview Road at the time that it made those recordings in the GPS Apple Health data? He answered yes. He understands he was using Waze and it had made that recording. Green continues. That's why the finding that the 3-minute and 1-second offset brings into serious doubt if that time was accurate. And when you apply that to the location offset, then Apple Health data and all the GPS align. He states he has not decoded Waze and found out what functions they were calling. But the latest version of Axiom is bringing that up as an artifact, as a timestamp related to Waze. And in this case, where minutes are important, he thought it was proper to bring this to the attention of the case as a possible explanation.
That was an interesting point that he said. If that 3-minute, 1-second offset is accurate, then everything, the Apple Health data and the GPS data aligns. I don't know if we have enough information from the exhibits that have been presented to draw that all out and really dig into that. That'll be interesting. Maybe we find some time to do that. We'll see and talk about that more on another episode, maybe.
Right.
Or for grins and giggles, some of the listeners out there could do it and tell us what they find.
That's right.
And let us know if you've worked that all out. If you're a digital forensic examiner and you grabbed those exhibit and worked it out, let us know.
We'll bring you on the show and talk about it.
Yeah, absolutely. Okay, so next he's asked a question. The 3 different clocks that you were talking about, are you aware that those are actually associated with power usage and not applications? He answered, right. The power usage was directly related to the Waze application. Asked, so it's your testimony that those 3 clocks apply to the times and Waze. Is that your testimony? He answered, the timestamps were directly related to Waze. It was reported by Axiom that when you applied the filter and said, show me all the artifacts related to Waze, these were the artifacts that came up related to the Waze bundle. He says you need to give it the weight it deserves. He's not decoded Waze, but he thinks we need to consider that 3-minute offset as it applies to giving significance to the Apple Health data and Waze GPS. And I think I mentioned this last week, but the Power Log database is the only database on the iPhone that uses monotonic time. Now, during his testimony, Green didn't bring up any other specific artifacts from Waze that had any specific times associated with that. I would guess that there would be some, but they have not been introduced.
So the prosecutor begins, now turning to Miss McCabe's phone again. As far as the search, what you indicated as last view time, are you aware that that is actually related to a time that was actually focused on the screen as opposed to your interpretation of it? He answered, he's aware that appears to be the last date and time it was focused, and when it was no longer in focus, that's when the timestamp was written. And that's what's consistent with the other data on the particular phone on this very specific iOS. Next, Green agreed he used Artex and was aware Mr. Whiffen created it.
Then the prosecutors asked, with regard to this specific issue, as far as how this data is being interpreted from the browser state DB versus the KnowledgeC database and the WAL file and the plist and all those other kind of things, has the misinterpretation of the data caused Mr. Whiffen in further revisions of Celebrite to revise this so that this kind of error doesn't happen again? Now, if you can't remember, this is our commentary. It's been a minute, but basically all of this kind of got kicked off because there's this search term being reported in Celebrite that says house long to die in cold. It has its URL and then the infamous 2:27 a.m. timestamp that's being reported in Celebrite in the area where it reports search queries. So I'm sure, like as a person who's using Celebrite regularly, you're going to look for search queries and you're expecting to see search queries that are coming from places that people search for stuff, like in Safari in their internet browser. And if they're using Safari, it's coming from History.db. And I'm sure I'm oversimplifying right now, but basically what that artifact sections with the search history does in Celebrite is kind of put anything in there that looks like a search query into that artifact section so you can look at it. But remember, the tool is searching based on coding and patterns, up to the examiner to dig in and interpret the data. So, I mean, this is kind of where it got it started. You know, Green called, other people called on other cases and was kind of like, what's up with this search term in here coming from the browser state DB?
That's right. He answered, Mr. Whiffen's testing was not done with this specific version of the iOS. The iOS has been known to be changing the way this artifact works. To do proper analysis or research, he would have needed to work with that same iOS. With regards to the other question, they have two versions of the Celebrite Physical Analyzer, and they have a new version called Insights. And it's only the Insights version that they have bothered updating and is no longer reporting on that time. Their current Physical Analyzer program, he tested this a few days ago, still reports on that search occurring and that timestamp. Currently, Celebrite is providing examiners, law enforcement, and people worldwide with two different versions giving two different results. The prosecutor states that the question was, yes or no, are you aware that Celebrite has had to modify their software based on misinterpretation of data, as you've done in this case? He answered yes, with the asterisk that they updated one of the two programs.
You know, and he's pointing out that Celebrite has two different versions of the software. One is giving one set of results by showing that search result, and the other one is omitting it, and so it's giving a different set of results. But we said it before, the data is still there. If you were examining the browser state.db, then you would still see that search and you would still have to figure out what, if any, significance some of that data had to your case. Will you manually open it if it's not provided to you? I don't know. Depends what's pertinent to your case. Is it really internet history heavy? Does that matter or does it not? I don't know.
Yeah, for sure.
But so with that, that is the end of his testimony under cross-examination from the prosecutor. The defense declined to ask him any more questions. So this marks the end of Richard Green's testimony in the first Karen Read trial. Becky, any points you want to go back and discuss from this episode, or we can even go back to the last episode if something from today got you thinking?
I just say that this digital forensics is extremely technical and can get lost in the weeds if not documented, communicated, done well. And that's why attention to detail. And I'm not saying that he didn't have attention to detail. I'm just saying that the way these questions are being swung at him,
Yeah.
right?
Especially in the cross, you don't know
Sure.
what's coming.
Yeah, and it's confusing. And you know, attorneys might be using strategic ways to confuse people, especially the witness. And so I would just say, like, Ian Whiffen and Jessica Hyde, they wouldn't change their answer as the testimony went. And I feel like Green might have contradicted himself a few times in his testimony. And that's just because of the way the questioning was being given to him.
Yeah, there was a couple of times he definitely contradicted himself because, and we talked about it in the last episode, but a lot of it was about the arrival time of O'Keefe's phone at the address. And he said, it arrived here at this time. Boom. That was his testimony. Simple, straightforward. But then later on, they start introducing some Apple Health data. And so now they're saying that the times are all in question and the monotonic time is throwing everything off. But really, to figure all of that out, you would have to spend a lot of time looking at a bunch of different artifacts, and you have to correlate all of those different artifacts together. Now, the one nice thing that Axiom did do with that Waze artifact that he was looking at in that monotonic time, it had the two other clocks listed right there. So you didn't even have to do any math on your own. It's all right there. So if there was a questioning of the times, you could look at that. But again, that would only pertain to the different artifacts that are using all the monotonic time. So it's like, did you find one artifact that is using monotonic time and you need to correlate it to another artifact from somewhere else, something else that is not using monotonic time, then that would be super slick to look in Axiom and be like, oh yeah, it says, the clock time, the wall clock, display time, whatever word you want to use, the display time is this. And then, oh, I see that this is this. So then you can interpret, what does that mean? We don't know how much time he was given in the case. That's always the struggle on the defense, especially if you're working with the public defender's office. It's like, here's 16 hours and PS, we need you to write up a report within that 16 hours. And report writing can take a long time. And I mean, that affidavit was not short. So I don't know how that long that took him to write up either. But I don't think his attorneys did him any favors in terms of the line of questioning his own attorneys, because it wasn't, I was struggling to find, like, what is the story? What is the order? What is driving this all together? I didn't feel like there was that build. There was no connection between the dots. I want you to tell me a story, connect the dots. That's our job as examiners. We've got to tell the story in a way that other people can understand it and connect all the dots for them, especially for the jury. I mean, it's hard enough to do it for each other sometimes, like as we're sitting here trying to explain this stuff on the podcast. And we spent like 40 bajillion hours looking at this Karen Read trial. It's possible I may have spent more time examining some of this stuff than he did. And you got to do with what you're given. And they didn't do the thing because sometimes your defense attorney will say, how much have you been paid and how many hours have you worked on this case? So then you kind of know that going into it. Like if he said he got paid for 400 hours of work on this, I'd be like, man. But if he said, oh, I got paid for 16 hours, then I'd be like, yeah, I see why your answers are this way. And that's just something we don't know.
Yeah, that's exactly right. Well, all right. If you are enjoying these episodes, please leave us a review wherever you listen. It really helps us expand our reach. So join us next week for our final wrap up of the first Karen Read trial. Until next time, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you enjoyed this episode, make sure to follow us to get notified the next time a new episode drops. If you can do more, head on over to parsingthetruth.com and donate by clicking on the donate button. Parsing the Truth is a nonprofit organization, and we are raising money to send a new digital forensic examiner to IASIS training next year in Orlando. Thanks.